Bombshell investigative reporting by Old Pav. Cy Ray and defense team are about to free Bryan Kohberger. Let's roll. Ladies and gentlemen, thank you.
Listen to Pavarotti.
Can I be your superhero?
Hello, welcome to The Revealing. I am your host, Pavarotti, and I'm here to discuss the Idaho 4 case. And if there's ever a video that I've put together that everybody needs to see, it's going to be this one right here. When I say this one's hype worthy, this one's hype worthy. This is what everybody's missed with the Cy Ray interview. And by the end of this, you're going to understand so many things about this case that you didn't understand before. And you're going to understand exactly what the end game is, how it's going to get there, and what Cy Ray was really doing in that interview. Okay, so now I've done some videos since then trying to set the stage for this video. And I know I've been hard on Cy as it relates to some of the things he said, as it relates to things that are actually involved in the investigation, his determinations of things that led him to believe Bryan's guilty. I don't know that Cy Ray really believes Bryan's guilty. He may. I don't know that he does, though, but I do know that there's a tightrope that Cy Ray has to walk. And I'm gonna, by the end of this, you're gonna understand everything that I mean when I go through this. So you have to really watch that interview carefully to see the things that Cy Ray was talking about that actually are predicate of what's about to happen in this case. And it's hard for me to even go through and verbalize all this. So I'm going to do it in a very structured way so that you know what Cy Ray was really trying to convey. And really, if you're an attorney, if there's any attorneys out there, watch this video from start to finish. And I think even you are going to be amazed at what Cy Ray has laid out for us, the truth about where this case went sideways, how everything is infringing on our rights as citizens, what the FBI actually did when they took the profile from Othram Labs and doubled it in size, and why what they did to double it in size infringes on all of our rights, especially our rights as it relates to HIPAA. Oh yeah, this thing is huge. But instead of me going through and trying to explain it all, I'm going to go through and we're going to do it in a very controlled and concise manner using Cy Ray's own words, pulling from different parts of the interview so that you can see what he was really trying to say. We could argue all day about the time of the crime, the cleanup, the hair in Ethan's hands, you know, the route Bryan Kohberger took. That's not even what he was trying to convey in this interview. Cy Ray is a CSLI expert, right? Cy Ray talked about many things in this interview that had nothing to do with CSLI, but he talked about them in a way where he really had some knowledge about things that you wouldn't expect Cy Ray to have knowledge about. And I believe that if you listen to what he was saying, Cy Ray is aligned with the Kohberger defense team. Very much so. One of the reasons I believe he took this interview was to debunk a lot of the things that Turvey said, who is not aligned with the Kohberger defense team, as we're going to find out. So anyway, hold on to your hats, folks. You're about to know so much about this case by the end of this video. So much about things that we thought we knew that we didn't have correct. And by the end, you're going to understand the way that I understand it, that Bryan Kohberger will not spend the rest of his life in that penitentiary. Hold on to your hats. First of all, we've got to understand, and I brought this up before, but you got to understand the tightrope that Cy Ray has to walk. So when you hear Cy Ray in this interview talk about BK is probably guilty, but the investigation is bad Therefore, what everybody should be mad about is a killer may go free. He says may go free, not could have went free. A killer may go free. That's Cy Ray's way of walking the tightrope of what he's involved with about what's to come to save his current relationship with law enforcement. So you got to understand, Cy Ray has written a manual. Like I said, it was never a novel. This was always a manual on training law enforcement on proper techniques. He said that he's already been across the country teaching this. Cy Ray is a law enforcement officer. He has come up with programs on this technology that he's passionate about. So for Cy Ray, it's best for him to align with the fact that Bryan Kohberger is likely guilty, and law enforcement doing the things that they did in this case is the reason Bryan Kohberger is going to be free. Therefore, they shouldn't do these things again, if that makes sense. For him to come out and say that, no, they've done this and they put an innocent person in prison, that would totally make Cy Ray in opposition of everybody that he's teaching. So he would lose all credibility in that respect. So it is a tightrope that he has to walk, and you have to understand that first. Now, when Cy Ray talks about in this investigation, it was an end justifying the means. Again, that's another example of him having to walk the same tightrope. I believe in my heart that if we ask Cy Ray, did he agree or not agree with the words of Benjamin Franklin, that better 10 guilty persons escape than one innocent person suffer, I believe Cy Ray would agree. But this statement by Cy Ray is him walking that tightrope.
In this case, it was very quick summary that I realized I was dealing with a case where the end result justified the means. And therefore, yeah, there was a moral obligation of a standard that I felt that I had taught and put out there for law enforcement and spent a lot of time in court showing the scientific, reliability of it was being challenged or was at stake. And that's a ripple effect that, impacts the entire criminal justice system, not just a case in Idaho.
Now, I'm very confident in my Cy Ray walking the tightrope theory because I have gone through his report that he actually had written and analyzed in this case with a fine-tooth comb, as y'all know. And where I can see it in real time is when Cy Ray is walking the tightrope in this interview. He's trying to contradict his actual report. And you can see exactly how uncomfortable that he became when Ron at one point began asking him or quoting out of his report, Cy Ray's own words. As Ron was reading his words in that report, Cy Ray turned bloodshot red and started shimmying around in his seat. And you could tell he was very uncomfortable because he knew what he had written in that report was not what he was conveying in the interview.
Talk about these historical precision location information reports, which I understand is proprietary with AT&T, but those are not always available. I guess the phone has to be doing something for it, but AT&T can actually give when it does ping, like as part of that. And I want you to correct me if I'm wrong in my understanding. It'll give you latitude and longitude within a certain number of meters. Is that information, the historical, the HPLI, was that used by the prosecution and law enforcement?
So again, it's an example of him trying to walk that tightrope in the interview, trying to go against what he actually said in that report. And I can understand why he did it at this point. But let's keep going. But again, that's him walking the tightrope. The other example of him walking the tightrope is him continuing to frame that both things can be true. Bryan Kohberger could be guilty. The investigation could be faulty. Therefore, both things could be true. This is very important for Cy Ray to frame things in this manner.
I wanted to probably say this before, but now is as good as time as any. I think to have a real conversation, and this is both with all four of you, or all three of you rather, and your audience, there's a handful of things as a group I think we all have to agree on to even have a real conversation about this case. And the first thing is, anybody who says, I will never believe that Bryan Kohberger could have committed this crime, that's great. That's your opinion. I respect your opinion, but we can't have a conversation if that's where you're starting this thing. You know, if you're never going to believe that, what are we even doing? You have your opinion, I have mine, we'll go separate ways. So number one, we all have to agree it is plausible, it is possible. The second thing is we all have to understand this investigation could be so faulty, could have so many issues in it that it could actually not support a conviction if it ever went to trial. Like, we have to understand that is a reality of this case. And the third and the most important thing is we have to all agree that both of these things can exist. It's not one or the other, you know, and I'm not talking about innocence and guilt in trial. I'm saying it is very plausible that Bryan Kohberger committed this crime. And it is also very plausible that this investigation has so many errors in it that it is potentially corrupted from ever actually showing justice through a trial proceeding or through a jury.
So there's your first hint that what Cy Ray is laying out here is this thing will never go to trial. Justice will never be served in a trial setting, he says. And when he goes on to say 10 out of 10 jurors would convict in this, it's again his way of framing the argument that because of what law enforcement did in this case, it's possible that a guilty man is going to walk free and there will never be a trial. Hold on to your hats, folks. It's about to get real. Then Cy Ray starts to lay out exactly what is to take place. He does it first by making sure that everybody knew that the roadmap starts with fruit of the poisonous tree around the IgG. He specifically points to the Jeff Nye interview that I did a video on actually a year ago, and I replayed it with Cy Ray's words yesterday, or maybe it was the day before, because it's the critical part in the hearing where the judge hears the argument around IgG. If the judge rules against the prosecution in that argument, all the evidence in the case is then thrown out from that point. Very important for you to understand that, because that is going to be the argument that wins in the end.
When we add the legal issues of how you can obtain that evidence, the proper way to analyze that evidence, the proper interpretation of that evidence, now we get to kind of a 50-50 thing. I think there's probably 50% of the courts throughout the United States that would have suppressed a lot of evidence in this case, enough so that a conviction may never be obtained. And, you know, if anybody doubts me or they're like, that Cy Ray guy, he's crazy, he's a conspiracy theorist. If you don't believe me, all you have to do is simply Google Jeffrey Nye, Fox News. And Jeffrey Nye is one of the AG, the attorney generals in Idaho, who did all of the oral arguments in court as it relates to the DNA evidence in this case. And if you listen to that interview, he'll tell you firsthand, everything was at stake on the DNA. If they lost the DNA, everything that comes behind it would have been gone. And he'll tell you that's a lot of evidence. That's all the cell phone records. It's all the Celebrite extracts. It's everything. And then he'll go on to tell you that they didn't even argue for some other exception to that rule, to the fruit of the poisonous tree, if you will, because it didn't exist. So, you know, you have a major player on the prosecution side who's telling you, when we went into court to argue that we felt the IgG would be upheld, the legal process in which we got it, we knew we were risking everything.
And that's where the blinders are now off of me for sure around this part of the case. This is the most critical part of the case. You're going to hear Cy Ray start talking about technology outpacing the judicial system. He's actually framing what took place with the IgG, and now it's so clear.
This is a really important thing. When I say technology has outpaced our understanding of it within the rule of law, this is exactly one of the things that I'm discussing.
Later on, he talks about how the FBI doubled the size of the S&P profile, something we have been in the dark about this entire time. We've had to speculate. How did the FBI get a profile that was double the size of the Othram profile? Now we know how they did it, y'all.
But the decision was made to go down IgG. The problem is when the IgG did not produce the initial results that they were hoping for, there was a decision made to go even further outside of those guardrails. And this is where Othram was told to stop work. The FBI took over. There's some things that happened with that sample. And in my opinion, this is where law enforcement needs to be held accountable. And I'm saying that as a law enforcement officer for 20 years and someone who's helped law enforcement for the last 15 years and currently today is still working with law enforcement on cases.
And finally, the IGG portion of this and how it relates to the doubling of the size of the S&P profile by the FBI and what really happens when they do that. And that's where you get into the real privacy issues around things in this case. And finally, how privacy meets firsthand with the rules that the DOJ ignored. And it wasn't just going into databases that infringed on the database's own policies, but it was actually infringing on all of our rights as it relates to HIPAA and our personal health privacy. And that's where bioinformatics comes in. That is what Cyray is really talking about in this, is the FBI's use of bioinformatics, which doubled the size of the S&P, and how that relates to our health privacy laws. And that's what I never could figure out, why the defense and the prosecution were walking the tightrope in the closed hearing about health and privacy. Now it all makes sense. And in the new unsealed documents, we know that the expert report from Leah Larkin tells us the FBI file is more than twice the size of the Othram one. So presumably they used bioinformatics to create the new information. Without access to the original data, the defense cannot adequately evaluate the scientific work. But it's the use of bioinformatics that doubled the size of the profile that actually infringes on our health HIPAA rights. In forensic genetic genealogy, FGG, also called investigative genetic genealogy or IgG, bioinformatics tools analyze DNA data, primarily dense single nucleotide polymorphism profiles, to identify distant relatives and build family trees for law enforcement investigations. This process can inadvertently or directly generate or expose health-related genetic information protected under privacy laws like GINA, the Genetic Information Non-Discrimination Act, and HIPAA, which treats genetic information as protected health information, or PHI in certain contexts. So simply the use of bioinformatics by the FBI in doubling the size of that profile inadvertently or directly violates privacy rights as it relates to our health information, which is why this argument in the closed hearing was so important. But it's not just bioinformatics. Leah Larkin also goes on to say that Othram advertises forensic-grade genome sequencing, but based on the size of their data file, they may have done a microarray rather than the whole genome sequencing. She said that before she even brought up the fact that the FBI then used bioinformatics on Othram's microarray. Why is that important? Because in the closed hearing testimony, is there any aspect in your field where medical information can be known? Yes, so the DNA tests that are used for genetic genealogy are called microarrays. So when you spit in a tube and send it off to one of those companies, they're going to do what's called a microarray. A microarray test was designed for biomedical research. They weren't designed for genealogy. Genealogy was like an afterthought. These are tests that were created specifically to target physical traits, health traits, and it just happens to be useful for genealogy as well. So even if I do a test and don't look at those traits, they're still in that data file. When you get to the work, do you have to make a choice as to what kind of database you're going to do your research in? Yes. So if I'm taking a client who is, for example, an adoptee, I will have them tested Ancestry and 23andMe. So those are two companies where you actually have to send in a spit sample to get into their databases. They don't take data files from other sources. The most cost-effective way to do this for an adoptee is to test at those two companies and then take one of the data files you get from, say, Ancestry and upload it into the smaller databases. That way you don't have to pay for a whole new test. You don't have to wait to mail it off and have the lab run it and get back the results. You can normally get your results in a day or two after you do the upload. So for an adoptee, there aren't really restrictions on which databases you can use because they were all generally created for amateur genealogists. Well, we talked a little bit today about databases that have restricted use. Yes, what does that mean? And then they get into the other databases. So what makes it clear in this is the fact that they use the other databases not because they were protected, but because they use the microarray and the bioinformatics to be able to use those other databases which produce protected health information. This is what Cy-Ray is talking about as it relates to the privacy. And this is where it gets huge. Pay a close attention as we go further.
But I also feel that we have to properly use it. There has to be a legal process. That legal process has to be transparent, and we have to have the public's trust that we're doing it properly. And when we make decisions to go intentionally go outside of policy, conceal, hide, and omit the process that we did, I think that cuts to the rule of law completely, and everything that you guys probably see on a daily basis that you fight for, right? We have rules for a reason.
So you may be asking yourself, why would Cy-Ray spend this entire interview not only contradicting his own expert report as it relates to his expertise, but actually spend the majority of this interview talking about things that are completely outside his expertise? Mainly, if you really paid attention to this interview, Cy-Ray talked more about IgG than anything else. And it's quite clear now why he did, because he knows what's going to happen going further. And he told us, if you paid attention, he told us. And what he told us can be backed up by the law, as we're going to find out. And for those attorneys out there, I want you to really focus in on what I'm about to show you right here. And this is in the judge's order on the motion to suppress the genetic information and what the defense's argument was. In the occurring opinion relied upon by defendant, one justice disagreed with the majority on this issue because, given the sensitive genetic information revealed by S&P testing, he would have required a warrant before allowing such testing. He further opined that the concept of abandonment, which requires voluntariness, is an ill fit for genetic information because it is virtually impossible for humans to prevent leaving personal genetic information everywhere they go. To this end, he analogized DNA to the cell phone site location information, CSLI, at issue in Carpenter versus the United States, where the United States Supreme Court reasoned that CSLI is not voluntarily exposed, given that virtually any activity on a phone, which is essential to participate in modern life, will leave a trail of location data. Citing Carpenter, while there are safeguards to prevent the dissemination of CSLI, i.e. turning off a phone, he observed there are no similar safeguards for DNA, thus rendering the case against abandonment all the more clear. When we venture into public spaces, we simply cannot help but shed our DNA. The judge ruled against the defense on this motion, and the defense preserved their objection using Carpenter as their objection. This is very important because it's preserved and it's on the record for this. Keep that in mind. Now, for this all to come together, certain things have to take place. And Cy-Ray, for those with eyes to see and ears to hear, laid it out brilliantly in this conversation. The roadmap for what is to come. He starts with post-conviction relief. and how the defense will actually get this case back to trial status, because that's number one.
And requested a continuance. And she made a very good argument that, hey, I don't know what I have. And I think the judges, and to me, this was a really interesting statement. You can't ask for the world and then complain when you get it, right? So it's almost like, how dare you as a defense attorney ask for evidence, and when you're provided it, complain that you don't have time to review it on the night before trial? And I'm obviously using a statement there.
I would be furious at a judge who made that comment to me as an attorney if I had been trying to get this, and all of a sudden, well, here you go on the eve of trial.
100%.
So I can kind of see where she would be on that.
And more importantly, what she said next. Your Honor, I cannot effectively represent my client without this continuance. We have the lead defense attorney saying in open court on the record, I cannot provide adequate assistance. What does that mean? The door for appeal is wide open. Mm-hmm. And, anybody who's like, well, then how does that factor into the appeal? Garza versus State of Idaho. Just go do some reading on Garza versus Idaho. Time is on their side. So, the plea deal does not surprise me when I look at the rulings we got, and I'm saying from the defense side, what happened in open court and the lead defense attorney saying, ineffective counsel, I can't effectively represent my client. A plea deal stops everything. It prevents. And why is everybody being so secretive? Because it stops everything from being discovered. The defense doesn't have to reveal their tactics. They can sit back. They can review everything now. They're going to get another bite at the apple, potentially, depending on how potential rulings come out in reference to Garza.
And see, that's where you have to have been listening on the third level this entire interview for you to clearly understand what's going to take place. See, that's where Cy Ray took off his law enforcement hat and put on his other hat, like he said we. When he said we, and then he had to hurry up and clarify, I mean the defense team. He laid it all out right there, just like we've talked about this entire time, by taking the plea deal. It froze everything. When he says discovery, he means the defense discovery to the prosecution. It froze it. It gave the defense all the time necessary they needed to go through all of the discovery. But he repeatedly mentioned it depends on how the rulings come out as it relates to Garza, and go look at Garza and how that applies. I never thought the defense would use this tactic, but why not? It is the simplest tactic to guarantee that you get back to trial status. You see, in the United States versus Garza, or more specifically, Garza versus the United States, it's a very simple process, and it guarantees to overturn the plea deal and put you back at trial status. All they had to do was, any one of Bryan Kohberger's attorneys was document any statement from Bryan Kohberger to that attorney during that 42-day window that Bryan Kohberger asked them to file an appeal. Them not filing the appeal in that 42-day window and proof that Bryan Kohberger asked them to is a literal guarantee with Garza v. Idaho to overturn the conviction and put it back at trial status. There's no arguments around it. I didn't think the defense would use that tactic, but in retrospect, it's the only way you can guarantee that you get the case back to trial. All they had to do was just say, here, Kohberger, write this letter telling us to file. We won't file. We'll use that letter just to get this thing reinstated, and it's ironclad law by the U.S. Supreme Court. That's step number one. He'll file post-conviction relief, cite Garza v. Idaho, say Kohberger told them to appeal and they didn't, and that is instant ineffective assistance of counsel. And the ineffective assistance of counsel won't matter because any attorney can handle it from there, because once you get it back to trial status, now it becomes an ironclad decision around the IGG that was overturned and the defense preserved Carpenter. And Cy Ray lets us in on what that is. And it tells me that also, because Cy Ray misquoted the case file, that Cy Ray tried to memorize this stuff before this interview to get this out. And his memory just wasn't that good because he misstated the case that he was actually trying to state. Watch.
You just made a really good argument of my earlier point of how we share DNA. So when you go into databases and you're searching my familiar DNA, you are searching my DNA profile that I have an expectation of privacy to, even though you're the person that loaded that DNA profile into this database. And that's why it requires a warrant. Garrity just came down from the Supreme Court, and Garrity could not be a better case for Bryan Kohberger, because it says very clearly that when consent is involved with people loading stuff into databases that law enforcement has access to, it requires a search warrant. I think that IgG is a very powerful tool, and who doesn't want to solve the 1976 murder or rape case? Of course we should be using tools like this. But with a powerful tool, there should absolutely be guardrails that we require our law enforcement and prosecution teams to follow to the T. Because when we don't, it jeopardizes the integrity of the entire investigation. Garrity just came down from the Supreme Court, and Garrity could not be a better case for Bryan Kohberger.
The case that Cy was trying to cite was actually Chatry, not Garrett or Garrity. That's how I can recognize he tried to memorize it beforehand. It's Chatry. And what does Chatry do? It's a new U.S. Supreme Court ruling that just happened June 29, 2026 of this year. And what does it do? It strengthens the fact that law enforcement has to get search warrants to search things like location history for geofence warrants. They have to generally get a warrant based on probable cause when seeking this type of searching location data. It strengthens the digital privacy protections against broad reverse location searches that sweep up data from many innocent people. But how does that apply to the IgG? Similar privacy logic, like location data, DNA genetic information is highly personal and revealing. It exposes health, ancestry, family relationships, and more. Courts have increasingly recognized strong privacy interests in genetic data. Chatry reinforces that third-party doctrine, you lose privacy expectations when you share data with companies, has limits, especially for sensitive, comprehensive data like location or genetics. This could help arguments that uploading DNA profiles to public or semi-public databases doesn't automatically forfeit all Fourth Amendment protections. But where it really has an impact is it expands the reach of Carpenter versus the United States. And because the defense team preserved Carpenter in their objection, the new ruling on Chatry would expand that protection to Carpenter, and it would almost guarantee that if the Kohberger case goes back to trial status, a motion to suppress the genetic information based on the previously already preserved objection of Carpenter would enforce new expanded protections under Chatry and would almost guarantee the suppression of the IgG. And from that suppression, everything becomes fruit of the poisonous tree. After that, they have no grounds to retry Bryan Kohberger. Bryan Kohberger will be freed due to this ruling. Cy spelled it out for everybody that was listening.
A plea deal stops everything. It prevents, and why is everybody being so secretive? Because it stops everything from being discovered. The defense doesn't have to reveal their tactics. They can sit back. They can review everything now. They're going to get another bite at the apple, potentially, depending on how potential rulings come out in reference to Garza. More importantly, IgG is just now starting to have enough cases that it's being challenged at levels above the state of Idaho. And, a really critical IgG ruling could completely reframe this entire case. And the idea that the AG from Idaho actually goes on a national news media and says, we risked everything for IgG. And if we lose the IgG, we lose the entire case. His words were, it would be devastating to this case. We would lose everything. The plea deal makes 100% sense to me from the side of the defense. It is a smart move. And anybody who's like, I don't know what Ann Taylor's thinking, is playing checkers while Ann Taylor is playing chess. And anybody who's like, I don't know what Ann Taylor's thinking, is playing checkers while Ann Taylor is playing chess. And anybody who's like, I don't know what Ann Taylor's thinking, is playing checkers while Ann Taylor is playing chess.
So for any attorney out there, you should, especially if you're a guilty attorney, you should be very nervous right now as you research what I'm about to wrap in a bow for you. Okay? Take every piece of legal research that you can. Vet out. If Bryan Kohberger told the defense team to file an appeal, could have been just based on them telling him to do that, and they didn't. They can cite Garza v. Idaho on that, and it will almost guarantee that the case goes back to trial status. Then check the defense record on Carpenter. See that they preserved Carpenter in an objection. It is preserved and on the record. Then take the U.S. Supreme Court ruling on Chatry and apply that to the provisions in Carpenter. Then in your mind, think about the events like Cyree laid out right there so eloquently. The defense files a motion to suppress the genetic information based on their preserved objection, citing Carpenter. They include the new U.S. Supreme Court ruling with the protections of privacy coming down from Chatry. Think about how the judge has to rule on that now. The judge overrules his previous ruling, suppresses the genetic information, and then every piece of evidence that was gathered after the IGG on December 19th is suppressed. Fruit of the poisonous tree. Bryan Kohberger is released with no evidence to bring him to trial from that point. Please like and subscribe to this channel. Post your comments, your thoughts, your criticisms. Watch this video 85 times if you need to comprehend what I just described to you in this video, because it is a roadmap for what we're about to see. Pob's out.
Shot, only one of me to shield you all from the enemy. You're a superhero. You're a superhero.